Okay, hello everyone. I believe this is a good time for us to begin our webinar this afternoon. Just to be sure, I hope that you can all hear me. Can you please just give me some signal, a thumbs up, um, a wave? Okay, perfect. Great. Thank you so much for the feedback. Now I'm confident that you can all hear me and see me loud and clear. Thank you. Thank you so much, guys. So, good afternoon again, good evening, possibly even good morning, depending on which part of the world that you are joining us from. I'd like to welcome all of you to the CSTS webinar series, particularly today's webinar, which is on the topic Directors' Duties and Corporate Misconduct, Comparative Insights on Liability Regimes. So in case you have been wondering, CSTS is an organization which has been set up to strengthen the capacity of companies and entrepreneurs in core areas such as corporate governance, financial management, public and business administration, and many more. But we are also very much actively engaged in corporate governance advocacy and research. And this webinar series is one of the projects under our advocacy and research wing. So you are most welcome once again to this afternoon's webinar. So this afternoon we have put together, and in fact, we are very proud to have put together a stellar panel of young, dynamic, and very intelligent Ghanaian academics and practitioners who are doing amazingly well, both in Ghana and even outside Ghana in their various fields, which we'll get to know more about, to dissect the topic under consideration. My name is Gertrude Amokwama. I'm a lecturer at the UPSC Law School, and I'll be your moderator for this afternoon's discussion. In terms of what to expect, or in terms of the format, I'll briefly introduce our panelists, and then we jump straight into our discussion. Following that, we'll take some questions and answers from the audience to be addressed by our panel members, and then we can call it a day. But the comment box is also open. So in case in the course of the discussion, you have some thoughts, some comments, some questions, you can always put that in there as well. And then would address that in the course of, or after we are done with today's discussion. So welcome once again. So today we are joined by, let me first of all introduce Dr. Priscilla Vittor. She's a lecturer in law at the Loughborough University in England. Dr. Vittor, if you can hear us loud and clear, thank you so much for joining us. We are very grateful that you were able to make it here this afternoon.
Thank you for having me, Gertrude.
Great. And then, of course, we are also joined by my own brother and senior, Kenneth Gate, who is a lecturer at the University of Ghana School of Law. I know quite a number of you know why I'm referring to Kenneth as my own brother and senior, because we are in this business together. And we have been doing this for some time now. Ken, thank you so much for making it. I'm so grateful that you could join us.
It's a pleasure to be here, Gertrude.
Yeah, thank you. Okay, do we have Dr. Yamwa? Is Michael here with us as well? Our third panel member is in the person of Dr. Michael B. Yamwa. He's a director, he's an investment stewardship and engagement of Federated Hermes Limited, and also Pittsburgh, and also in Pittsburgh, in the United States of America. Dr. Yamwa, are you here yet? Okay, but Dr. Yama would be joining us pretty shortly. So when he comes, I'm sure he'll get the chance to say hello. So I think we can jump into the discussion for today. And I'm sure quite a number of us have wondered why the choice of this particular topic. For those of us in corporate practice and even in the research and academia, this is one of those subject areas that I think is so relatable and which all of us have so much views on in terms of the duties of directors and how this has, has some relationship with corporate misconduct. We are also particularly interested in looking at the insights, different insights on liability regimes. And that is why we have panelists from Ghana, from the United Kingdom, and also from the United States of America, so that we can do some comparative analysis to see whether there are some differences or similarities between the various liability regimes, and even when it comes to the scope of directors' duties and other relevant matters or related matters. So I want to start with Ken. Let's start from Ghana. And I know that we are joined by quite a number of law students, legal practitioners, business students, and what have you. So we want to sort of start from the basics. In terms of the duties of directors and in terms of Ghanaian law, very briefly, how would you conceptualize, or what would you say is the scope of directors' duties under Ghanaian law, Ken?
Okay, thank you, Gertrude. So maybe as a starting point, the directors are those who are appointed to administer the affairs of a company. At least that's how they are described under Ghanaian law. And because they are giving that power to administer the affairs of the company, they are also subject to duties. Uh, in the case of Ghana, our duties are clearly stated within our Companies Act 2019, Act 992. So for those who are not familiar, we had companies legislation from 1963 and until 2019, we updated our laws. But it didn't change significantly. So the laws, the duties of directors were indicated in the previous Companies Act and have also been restated here. But when you look at directors' duties under Ghana law, directors are supposed to do five main things. The directors are constituted as fiduciaries, simply meaning that they have to do their very best to ensure the success of a company. Secondly, the directors are also required to act in the best interests of the company. And what has changed uh, in our new law and the Ghana law is that in the past, directors were only told to act in the best interest of the company without any guidance. But the Companies Act 2019 specifies what those directors must do, that they must think of the business in the long term. They must consider the operations of the company uh, on the community and the environment. And then they must also desire that the company maintains a good reputation over a long period. So that's for the second of the five requirements. Thirdly, directors are required to act in accordance with the company's constitution. So typically, a company has a constitution that defines the powers within the company.
Shut the
The
fuck up,
directors are
man.
required to act in accordance with that constitution. And because directors are giving powers, significant powers in managing the company, Ghanaian law also requires directors to act for a proper purpose. You can have power, but you can misuse that power. So directors are significantly required to act for a proper purpose. And the fifth one, which I would end with, is a new one which was introduced under our more recent law reform, that directors must exercise independent judgment. If you look at the context of what happened in the last, I won't go into the details, but with the bank insolvencies and those associated events, you would realize that many directors tended to follow the opinions of a very dominant director on the board. So Ghanaian law now requires specifically for directors to exercise independent judgment in giving effect to all the other duties that they are required to perform within the company. I hope this has been fairly brief.
Yes, amazingly well. Thank you so much, Kenneth. So I think I'll just move on to Dr. Vitor to find out from her how different or how similar the scope of directors' duties in the UK is compared to what Ken has just told us about the Ghanaian, prescriptions. So over to you, Priscilla.
Yeah, I think listening to Ken, it was just as though he's talking from our Companies Act. So the director's duties within the UK is quite similar to what is in the Ghana Companies Act 2019. However, our act is a bit older, it's 2006. So it states basically everything that Ken has said. Acting in good faith and in the best interest of the company, exercising reasonable care, skill, and due diligence. I'm not sure, Ken, if you mentioned that as well within the Ghanaian system, but that's one of the things that
Can you stop talking for a minute, please?
Sorry about that. Please go on, Priscilla.
So exercising reasonable care, skill, and diligence is one of the main duties for directors here. And in this regard, what the UK law does is that it doesn't just look at the director acting as a director.
Stop talking.
I think you have a spammer in there.
Yes, yes, and we are working very actively to have this person removed. Apologies for that.
That's okay. Yeah, so with a reasonable care and skill, it looks at the skill of the director, as in what they are able to do in terms of first the duty in which they are in. So for instance, if you're a director of finance, then clearly the role in which you're in, the skills that you need to take over that role, or the skills you need to properly act within that role. But then it also takes into consideration the director's own personal skill.
What are you saying?
So so perhaps in terms of the director's education. So for instance, if somebody is a director of finance who has, let's say, a PhD in business administration, the Companies Act expects that they exercise skill based on that capability. So it's no longer the reasonable man on the Medina Trotro, or in this case, the Clapham Omnibus, but a person who has the skill set that that director has. And then also in terms of the avoiding conflict of interest is one of the key directors' duties here, because like Ken was saying earlier, directors are the ones who run the show within the company, because even though the company is a legal person, they can't, they're artificial persons, isn't it? So they can't do anything on their own. It is the directors who will run that. And if the directors are doing that on their own, in their own interest, then the company will be in a lot of trouble. So that is one of the duties that is quite well policed. It doesn't matter if it is the company did not take up the offer, or the company could not afford to take up the offer. So far as the director has acted in a way that puts their interest above the company's interest without declaring it, that is something that is quite well policed within the regime here. I think I'll leave it as that for now.
Okay, thank you, Priscilla. So it's interesting how you started by saying that listening to Kenneth, it was as if he was just, rehashing. And I think the reason for that is it's quite obvious to all of us. The fact that, I mean, look, Ghana is a common law jurisdiction as well. And the fact that our company laws, to a large extent, is very, very it's modeled on the UK company law. So that's quite expected. But that leads to us hearing from Michael, Dr. Yamwa now, who has joined us. Is the situation quite the same in the US, in the United States of America?
So there's a massive, well, I'll say a little bit of a massive difference. Obviously, I'm not a lawyer. I do have legal training, but not at the sort of a JD, it's a legal studies.
Right.
And much of, just as a context, much of my work is actually around just corporate governance, both here in the US and the UK, and a little bit of also Asian markets as well. So in the US, it's state-driven in terms of the legal spectrum. Although I would have to say that we don't have the comply and explain sort of basis like they have in the UK over here. So over here, I think some of you may have heard about the SOX, Sarbanes-Oxley law, or other securities law, but it is mostly state-driven. Like, you have Delaware as an example. Now, US sort of regimes tend to be not that prescriptive. Obviously, we don't operate with like the EU within a civil regime, which is more dictated through some sort of statutes, legislative wise. Although statutes do exist in common law, exist within some of the Commonwealth sort of aspects of this sort of country in the United States. So a lot of the things that we sort of focus here, especially as a member of the National Association of Corporate Directors here in the United States, is that we focus on a lot of things that we could talk around duty. So duty of care, duty of loyalty, and a lot of the sort of other due diligence. In the US, it's as a Ghanaian, and I know someone who has lived in the UK, but also living here in the US, it is less about just stating the law and more about what we tend to use over here is how you contextualize the law, right, within the role that you sort of play. So if you're a board of director in the US capital market system, your role, unlike the UK, is not it's not to manage. It's purely oversight. There is no instance where you can manage. It breaches a lot of SEC sort of requirements. So we tend to say that we have three layers to. You have investors, you have the board, and you have management. Management's duty is to directly manage. The board is only to be responsible for strategy and oversee management sort of actions. But the board must always act in the interest of those shareholders, whether it be private or public. And on the legal spectrum over here in the US, you've seen some cases like, for instance, that happened with Tesla here and some other big cases that have obviously the question always on the Delaware law, which has kind of become predominantly a bigger issue now, is really the duty of care and duty of loyalty. Where does your loyalty as a director lies, right? And in making those assessments, where did you kind of ensure that you didn't cross the line in your own interest or other things? It always becomes a very challenging high bar sort of example sort of to follow. So in corporate governance here in the US, compared to sort of the UK, it is much loose, and there's a historical significance to it as well. Long time ago here in the US on the legal spectrum, shareholders, both public and private, didn't really, or board directors didn't really have any accountability to shareholders, much less society, right? It was appointed in many ways, like private equity environment, by those interested parties, and they just did things the way they wanted. It changed over the 1920s and whatnot into what we currently have. So that's kind of how it kind of differs here, obviously, compared to the UK or the EU or in Asia, where it's more softer with a few hard lines.
Thank you. Thank you so much, Dr. Yamwa. But let me circle back to Ken. I know that in the earlier comments, we have tried to see, or even from the responses that our panel members have shared with us, we've been able to tease out one or two differences. But I know that Ken, for example, has done a lot of work in this area. So listening to colleagues from the UK and the US, how do you think these duties of directors that we have just discussed compare? Are there any key similarities and differences? And particularly when it comes to the regulation of corporate conduct in these three jurisdictions under scrutiny, do they appear to be more rule-based or more principle-based? I think Michael hinted at something like that in his earlier comment, but let's see if you have a different perspective or otherwise on this.
Yes, okay, thank you, Gertrude. With the theme that runs through a lot of corporate law regulation is that sometimes legal frameworks might set out what directors must do, and the language that is adopted in regulating their conduct is fairly open-ended. It gives a principle that directors have to meet, and it uses fairly open-ended language, and that's what's in the nature of a principle-based option to regulation. Or that jurisdiction might also adopt specific rules telling directors what they must specifically do in that context, and that would be the rule-based approach. Listening to Priscilla and Michael, I see that, for example, the UK law might specify a few more principles, 7 in scope. Ghanaian law might provide a 5-pronged framework. As Michael has told us, the US doesn't have a federal system, but it is particularly state-based, and the law of Delaware is one of the most that is chosen. So you see that a duty of care or a duty of loyalty runs through all the 3 different jurisdictions that we're considering. And at the very core of directors' duties are these 2 duties of care, duties of loyalty. And so even where different language is employed, you can have that theme running across. The directors would have to do what is in the company's interest by using the reasonable skill and care in the particular circumstances, and also to be loyal to the company. That, for example, directors shouldn't make profits out of companies' transactions or enter into transactions that put them in a position of conflict of interest with the company's own interest. So what I get from what has been presented is that, for example, UK law has a greater range of principles. US law is far more open-ended, but Ghanaian law is quite a good mix of rules and principles. Particularly in our case, we have to add specific rules because we don't have our system hasn't developed. The courts haven't had the chance interface with explaining what these duties are in practice compared to, say, the UK. So when we were reforming our law, it became necessary. For example, asking directors to exercise independent judgment. One would have thought that directors should exercise independent judgment, but because of certain circumstances which were noticed, it became important to add that specific rule to provide the context. So there are similarities of duty, of loyalty, and care. Ghana has a mix. The UK favors much more principle-based regulations rather than specific rules, and the US is rather a bit more open-ended on that score. I think you are unmuted. You're muted, Gertrude.
Yes, thank you for that heads up, Ken. But just a quick follow-up. Is it really the case that people are not really taking cases like this to court, or it's just the posturing of the courts that also does not let us see a lot of a lot of cases like these on the breach of directors' duties?
To be honest, I think it's both. Culture can influence corporate management. So the general societal culture has an influence on how people. So in a very litigious society, like my apologies, Michael, but in a much more litigious society like in the US, people will be more willing to sue uh, to get, a court interpretation of whether particular director's conduct amounts to the standard that has to be met. So you get the court intervening more, and sometimes in the context of our specific Ghanaian judicial system, where things might grind so slowly that people might come to the position that, well, it might be pointless. By the time the case may be decided, the value of the suit may be lost, even if they have won. It might be a Pyrrhic victory. So it's a mix of both. I think the nature of our general Ghanaian culture, if there's such a thing, influences whether we take up these cases before our courts and whether the courts have had the chance to provide explanations as to what these standards mean in practice.
Right. Thank you, Ken. So I think one of the reasons why discussions of this nature is so important and is quite relatable to many of us is the numerous instances of corporate misconduct, particularly in the context of directors taking actions or sometimes even inactions that deviate from, the legal requirements, the ethical requirements, or even sometimes the social standards that are required of them. It is true that we have these laws and regulations that stipulate the exact duties of directors towards the companies that they are directors of, but this has not in any way, well, maybe depending on which jurisdiction, but I think this is something that cuts across, has not stopped misconduct in numerous forms on the part of directors. But specifically, and I think I'd want to circle around to Priscilla, Dr. Vitor on this. When we look at the regime for directors' duties in these three jurisdictions, are there particular expectations on directors to actually take steps to prevent corporate misconduct? And really, you are free to just, look at the UK perspective or also take a swipe at the other jurisdictions that we are considering. Thank you.
All right. I won't take a swipe at the US jurisdiction because I do not know much about them, but I think it's mostly, like Ken has said, quite litigation driven, and that's also because of the culture that it's in. I think between the UK and Ghana, it's more oversight. So these principles are there set to in the sense guide directors in terms of what their duties are. And for the UK, there has been a lot of testing in the courts, so a lot of cases that have evolved since the 1800s, isn't it, that tell what the core principles mean, and a lot of even the laws that have been set, the director's duties that are set in the Companies Act, actually emanated from the courts. So it's judicial precedent that have become law, have become statute. And so my understanding is more in terms of oversight. And so for instance, in the UK, it's not specific rules, but in the sense of, let's say, principles, what the directors are meant to do, and that is mostly oversight. And so directors are expected not to take a passive stance with the companies. And even as Ghanaian directors' duty evolve, I think it may be about the same thing, where if a director is taking a passive stance. So for instance, why do we need to tell the director to take independent judgment, right? Because as a director, you're not expected to go and sit on the board and be passive or not take any action or not take part in any decision making and come back and say, oh, I didn't make that decision. It was my other directors, or is this predominant director who made all these decisions. And when these things happen, I don't know if some of our listeners know about the post office case that came up that has been unraveling in the UK for a while now, where directors took the internal assurances that were given by the other heads of the company about their system in terms of the post office, in terms of the accounting system. And when it turned out that this accounting system from Horizon was a flawed one, which was letting the postmasters be seen as stealing from the post office, which in fact was not the case, the unraveling fell on the directors because it was seen as they needed to have taken more action. They needed to have exercised independent judgment. They needed to exercise reasonable care and skill rather than relying on what other people were saying to them. I think within the UK system, there's a lot of expectation on the directors to actually be active in the management of the company. I think it all boils down to the fact that, like I said earlier, the company is just a person on paper. So if a director is listed as a director, whether executive or non-executive, and this just means that executive directors are actually part of the day-to-day running of the company and non-executives are not. Regardless of that, you are meant to take active participation in the company's affairs. And also, I was going to say something, but I've lost it. But yes, even if a person is acting as, let's say, what we call a de facto director. I don't quite remember if we still have that in the Ghanaian system. But if somebody is given instructions, acting as though they were a director, even if they have not been appointed as a director, the UK system is such that it captures all of them in. And I think we have the same rules in Ghana, isn't it?
Yes,
So that
yes.
you don't stand somewhere and give instructions on how a company should run and then want to run away and say, well, after all, I've not been appointed as a director. So I'm not sure if I've answered your question. I think within the Ghanaian system and the English system, the main thing is directors' active engagement within the company. And that is why if you are banned from being a director, or if you're declared bankrupt or are seen as not being able to administer your duties properly, then you will have to wait about 15 years before you can be a director again, because it's all in the sense of protecting shareholders' money and protecting the people that are dealing with the company.
Yeah, thank you so much, Dr. Vito. I think you make a very important point on expectations. And I think one of the reasons why we decided to, discuss this very topic on today's webinar is the fact that there appears to be quite a number of misconceptions out there about what it means to be a director of a company. There are many of us who are happy, when our friends, colleagues approach us and say, hey, I'm filling these incorporation documents. Can I just put your name there as a director? And they say, oh yeah, please, happily go ahead and do so. But we'll be looking at liability regimes shortly. But yes, under Section 170, subsection 2 of our Companies Act in Ghana, for those persons who have not been duly appointed directors, but they still hold themselves out or even knowingly allow themselves to be held out as directors, they are subject to the same duties and liabilities as if they were duly or de jure directors. So yes, it's very much applicable in our case as well. Let me quickly come to Michael. And one of the reasons why I'm so excited about having him on this panel is the fact that he has a lot of practice experience in this area. He has served on quite a number of boards, and he's still serving on quite a number of boards. But when it comes to Michael, Dr. Yamwa, the actual performance of directors' duties, and I'll be happy for you to take this from a very practical perspective. What extent do you think that the duties of directors by law actually influence corporate accountability?
Now, I actually was going to go there because in being a director, I think in any part of the world, one of the things that you have to take heart is not just understanding the law. It's also understanding the what I call the corporate governance sort of regime, right? It's so fundamentally important. I don't know much about Ghana right now, but both in the EU and even now Asia, but as well as I think even South Africa, where I do talk to a number of companies, and here in the US, we've always gone further in sort of making the argument that a better regime for how you actually get good directors and directors to perform is really looking at the shareholder and stakeholder environment. So in the US, obviously, it is shareholders, whether it's private or particularly the public sector, public equities, that gets to vote on who becomes a director. And that is, I spend most of my days doing a lot of proxy engagements, right? Where I will talk to a board chair or talk to a governance committee chair and ask questions specifically about why is this board director being appointed? What is the attendance? What is the specific skill set that they bring into the equation, right? To help the company on a strategy, M&A, those kinds of stuff. So there is a more active ownership, let me put it like that, compared to a passive ownership. Obviously, from what I'm hearing from Ghana, often it's sometimes you have state-owned enterprises be appointed by obviously government, much like Brazil, and other places where they would then be on board. And we, in our job, have had a lot of issues with some Asian market and some South American market, which is similar to some of the African market as well. But the core dimension here is that the boards are more effective. So we call something board effectiveness when you have greater independence, but independence is reinforced by that shareholder active environment, right? Where they are able to sort of participate in not just allowing big owners, in particular, what I in the equity side, let's the private side, just dictating who they get to select onto boards and do whatever they want. The second part of the equation, how boards really help, like in my role as a board member, like, and sometimes also talking to boards, you're looking at something we call the hard and soft part of director sort of participation. The hard is obviously what are the laws, duty of care, duty of loyalty, oversight. Those are the things that every director needs to. But in the US, we don't want board of directors to be sort of hamstringed by a bunch of laws. Because remember, oversight means that you're going to have moving targets, decisions are going to be made. And often you're not going to have a lot of app to do with. There's been a number of cases in the UK, and I know the UK colleague can talk about it. It's not just the post office one. There are a number of cases that have come up where sometimes the courts will ask leading questions. Questions like, did you seek external audit? Did you get additional training? Did you look at additional information? Did you set up a different committee? So in the US, that becomes very important, especially there's something called director exculpation, right? Which is sort of a legal regime, especially in Delaware, and now moving into other places where you could be held liable, obviously not for, I was looking at it earlier on, not for duty of care, but duty of loyalty, right? And if you look at some of the cases like Caremark here in the US, some of the legal cases that have come, the court was simply asking questions like, okay, how do we establish independence? So they'll go into board meetings, which is why it's so important. Board meetings are very important because as a director, you could end up being sued for duty of loyalty. And if there's a demonstration that you did not take all the required steps to actually protect yourself from that point of view, you could be held liable. So even though the US is a very litigious society, matters of corporate governance are harder to win, even on an independent level, simply because of the degree of evidence, evidentiary sort of posture that you have to provide just to win a case. So directors often will go further in trying to ensure greater independence, especially if you're a chair of a committee. And then secondly, as shareholders, which I don't know how Ghana will sort of react to, because in the US and the UK, based on stewardship codes in both those regions, and also in the EU as well, we have active shareholder, not activism, but active ownership in engaging and being able to sort of dialogue with directors. I talk to directors throughout the year. Part of that is what we call director access, right? It also protects them even under the duty of loyalty, because that's the fiduciary responsibility that we talk about.
Thank you, Dr. Yamwa. So thank you, everyone. This is still the Corporate Secretarial and Training Services webinar series. Today's discussion is on the topic Directors' Duties and Corporate Misconduct, Comparative Insights on Liability Regimes. So far, we've been hearing from our panelists on the scope of directors' duties in the 3 jurisdictions and the scrutiny, which is Ghana, the United Kingdom, and then the US. And we have also looked at issues relating to, the duty of directors to prevent corporate misconduct and even how directors' actions influence corporate accountability. We want to move into a bit more of practical insights. I do acknowledge that in the earlier comments, we have hinted at 1 or 2 scandals or 1 or 2 happenings as a result of corporate misconduct. Priscilla, for example, made reference to the post office scandal in the UK. But we want to get a bit more practical, and we want to look at instances or examples where directors' duties have actually either prevented, well, that one I don't know much of, or even contributed towards corporate misconduct. I'd want to start with Kenneth on this. So I wouldn't be surprised, Kenneth, for example, and feel free to deviate if you're not going to talk about our banking crisis, but whatever example that you decide to take, I'm happy to hear from you on what you think the exact role of directors in that instance of corporate misconduct was, and what could have been done differently. Yes, Kenneth, I think you are muted. Okay.
Thank you, Gertrude. The no law, at least in the human experience, no letter of the law can force anybody. We have meta legislation, we have all types of, other types of misconduct even outside of the company. And even though these rules exist, it hasn't stopped some people from misconducting themselves. So for me personally, the premise that, the scope of directors' duties might contribute to directors engaging in corporate misconduct can be a bit difficult to accept. Except that, if these rules exist, then and they are known, once the directors are misconducted themselves, there's a regime that responds to that. In a much more recent history, in the Ghanaian case, the banking crisis, the underlying theme that went through all of that was, that there were severe corporate governance lapses within the regulated financial industry in Ghana. But even more recently, in the last 2 years, directors of 3 banks have been removed, 3 banks with government participation, where the government was a shareholder. We heard about the board chair of a major bank being removed because he facilitated the taking of a loan. The facts are a bit muddled, but he facilitated the taking of a loan and took a cut. So he was removed for that, and for all that it is worth, one wonders why criminal prosecution did not there follow. But we do know that in the banking crisis, there's an example of successful criminal prosecution of a majority shareholder who influenced the board to take decisions which were considered a violation of the banking rules. So what I would say is that, the scope of directors' duties in themselves may not be able to prevent or might not contribute to corporate misconduct. But once corporate misconduct has occurred and it's a violation of a specific rule or principle, then the responses will be applied accordingly. But of course, if directors, like as provided under Ghanaian law, if directors are specifically told what to do, as we have under our law, then it's easier to catch them for violations, and it is much less likely for them to throw their hands in the air and say, "I didn't know what to do, so I'm not subject to an allegation of misconduct." Once you look in the law, I believe that the law is fairly clear, and with the relevant training, directors should be able to conduct themselves appropriately. Thank you. You're muted.
Right, thank you, Ken. Yes, I was just asking whether Dr. Vito happens to have some additional comments on that before we move on to liability regimes.
Yeah, I think what I'll say is that when it comes to the director's duties in terms of corporate governance, a lot of the times for our regime, the law steps in after the fact in that sense, because there are principles or rights that the directors are meant to follow. But because these are happening in-house within the corporation, and a lot of times these companies are able to hide it. And by the time the matter comes out, maybe the company is going into administration, and then the liquidator or the administrator or liquidation, and then administrator comes in and finds these things that have gone on. So in that sense, I think that perhaps there has to be a bit more, because just having the laws on paper, regardless of how well it's enforced, it doesn't really quite protect in that sense. Because, for instance, even with the post office case that we've spoken about, this happened years ago, and the unraveling is still happening, and you barely get any of the directors going to jail for it. They may face criminal charges here, for instance, but there isn't much it's rare for them to actually be convicted of those criminal charges. So maximum perhaps will be disqualification from being a director. But if somebody has taken some money and you're just disqualifying them, perhaps that's not really much. Or if the company has already gone down, thousands of employees have lost their jobs, and it's just about disqualification or winding down the company, then there's a bit more, much to be said about such regimes that are following just principles, and in that sense, coming in after the fact. And that's the problem with law, isn't it? Law always seems to come in after the fact when things occur. Yeah, I think that's a bit what I would add.
Yeah, thank you so much, Doc. But Michael, I think that Dr. Vito makes a very important point, which I'd want to hear from you about. You know, the reactive nature of the law instead of seeing some proactivity. Like she said, most of the time it appears as if the law only comes in after the incident or after the fact, in an attempt to correct whatever misconduct is being alleged or has actually happened. Is it really possible to have more proactive measures aimed at preventing these misconducts that we complain about, or it's just not possible? We just have to keep resorting to the more reactive approach of waiting for the incident to happen and then kickstarting the process of the law.
No, thank you. I think Kenneth said something also. Priscilla also said something that I thought was very interesting. I mean, you are lawyers. Post ante is always going to be the way the law works, right? You go after the fact, look at events, and then kind of resolve it. Earlier on, I mentioned to you the importance of what I call a good corporate governance code. In the US, obviously, you have to have an injury to go to the court, right? Somebody has to be injured. Whether you look at, I was trying to get a number of cases earlier on, and I know that most of you have heard about in the US, we have the Kmart case. It's a classic example of a lot of things that can go wrong when it comes to director oversight. You all remember Qualcomm, Enron, all of those things are classic examples in the US where a lot of things have gone wrong. So the law is always going to be post ante. Now, where I stress on the whole governance code, which the UK is actually in my work, when we actually are doing a lot of engagement with company boards around the world, where there is not a robust regime, we resort to the UK. Of in some cases the EU, but mostly the UK. So in absence of a good regime, we'll go to the UK because it has a much more sort of experiential sort of heritage when it comes to corporate law, particularly with the City of London, right? So when you get to that level, what you really want is you want an active shareholder base, because often the injury will come from the shareholder. So in a lot of the US environment, you know, and when I say injury, I mean, you are all lawyers, so you know it's an injured party, somebody who's been harmed by something. So in the US, the court will always going to make an assessment of whether you are a qualified litigant, right? And that is going to be based on what injury that you have incurred that allows you. And that always happens with a shareholder. So you have to be really robust in your shareholder regime and the corporate governance regime, because that's the only way you can proactively deal with a lot of these things in a post-ante environment. So what our clients, and so the work that I do, we have assets that we manage and advise. So I sit on the advisory side for a lot of institutional investors. We have about 2.1 trillion of assets under advisement. And what we do on behalf of our clients is what I do every day is I talk to board members and say, how are you looking at this? We had a recent incident maybe in Gaza, a recent incident maybe in Venezuela. You're an oil and gas company. You had a recent incident in Libya. You had a recent incident in the Russia-Ukraine conflict. Or there is an incident regarding sort of child labor or whatever. How is the board thinking about it? Our way is to try to get ahead of any potential lackadaisical behavior from the board and maybe use our leverage in the public equity realm to say we do not support a particular board member because we don't find that that particular board member has the right set of skills, is attending meetings very well from the disclosure in the proxy statements or in other sort of disclosure requirement. We haven't seen this board member actually act in good faith, right? So in that case, you're not talking about legal. What you're really emphasizing on is you're looking at board conduct, board effectiveness, board structure, both hard and soft, and you're making a judgment. And in many cases, if a board member receives significant low number of votes on the public equity side, they don't qualify for re-election the following year. That's how you do that. On the private side, obviously, the bigger shareholders, from an activist point of view, have to make the determination, those who are part of it. But on the public side, especially when it's a public equity or public company, you have a little wiggle room. So that's why I said I'm not sure what Ghana has done, but beside the law, I think Kenneth, you said this very, very, very well. The law can only do so much. And post events are always harder to prosecute because you're asking to prosecute somebody because you feel like the person failed a duty of loyalty. They did not commit to that. And they can come up with other evidence to that fact. So then it becomes evidentiary posture. And then somebody has to, on a panel, kind of make a determination whether that person actually failed in their responsibility, right? So we need a very good, robust stewardship regime. And you can easily take the one of the UK because in many cases, sometimes we take the UK regime as a kind of a higher bar standard.
Yeah, thank you, Dr. Yamwa. I think this is a good call, flowing from your point, to act that shareholder activism, especially in places like Ghana. I mean, in the UK and the US, there are lots of instances of shareholders, using all sort of measures to put really either very subtle pressures on directors or management actually to do things the right way. But it looks as if for other jurisdictions, our shareholders are happy to just sit back, wait for dividends at the end of the financial year, and then, but really it looks as if we need to take shareholder activism much more seriously. And then you spoke about corporate governance codes. In Ghana, we have made quite a number of strides in this direction to the extent that recently, no, I think not recently, quite a number of years ago, the IOD Ghana, which is the Institute of Directors Ghana, has put together the National Code of Corporate Governance. But of course, the usual challenge with regulation through soft means like corporate governance codes is the fact that they are not binding. So if you are having to employ either a comply or explain approach or an apply or explain approach, then there's quite some, space for companies to decide that, look, we are just not interested. I know we have some IOD Ghana members online, and I'm sure in the course of the question and answer session, we'll get to hear more from them. But I want us to move away from all these earlier matters and look at the actual liability regimes that comes with, breaching these duties that directors have. Because I think that having an effective, or maybe this is also debatable, I'm not too sure the extent of success that would have by having an effective liability regime. But really, let's look at the nature of the liability regimes in Ghana, in the UK, and in the US. What does it look like? What is the picture like? And secondly, how effective are liability regimes in curbing or even mitigating the incidents of corporate misconduct? I think I can start from Ken. He has been quiet for a while.
Thank you. I should say that any liability regime would be composed of first the rules that regulate conduct and then the enforcement back end of it. Okay, so you can have rules which tell people what to do and what not to do. And then once they have acted, we measure that action as whether it has breached the specification of what they have to do or what they do not have to do. And that's also a question of enforcement. Within the Ghanaian sphere, I would say, and the benefit of Ghana law is that our law, the UK has a notoriously slow-moving law-making process in which there are consultations upon consultations upon consultations before corporate legal rules are produced. Here we look at what is happening around the world. Smaller committees, there is some consultation, but contentious issues elsewhere are easily put into Ghanaian law. Take, for example, that Ghanaian directors have to consider the environment in decision making. This is one of the things which, is put out there in many other jurisdictions, but you seldom find it being, included within the law as one of the things directors have to come to. So specifically on the Ghanaian liability regime, it's a good liability regime. One, when directors have misconducted themselves, it can have civil consequences compared to, say, it can have both civil and criminal consequences. So if a director misconducts themselves, it might be a breach of company law. But those same actions can also be a breach of the criminal law. So within the context of the company itself, our Companies Act permits the shareholders and other insiders, and even including the board, because sometimes you have a situation in which only some board members have misconducted themselves. So other board members might then enforce it within the court. So we have both of those systems. And then there are also specially regulated systems, like for banking, where the regulator can take enforcement action, corporate governance enforcement actions within specially regulated industries. So when you look at our law on paper, I think, in my view, it is potentially even better than the UK system for liability regime. I'm not as familiar with the Delaware system if we are comparing it federally. So our law is fantastic on paper. But on the other side, however, you know, the process for actually getting directors to pay for bad conduct is far, far, far lower. So, well, our liability regime, the standard for what directors have to meet is excellent, but enforcement is where the challenge lies. And beyond regulatory enforcement, shareholders also don't tend to challenge director action, even in listed companies, unless there are one or two that we know who has, like a shareholder who has a stake in EcoBank and Cowbank, who writes to the directors all the time, sues them if threatens a suit if they don't want to take action. But that's rather rare in our Ghanaian environment. So, well, we're good with the letter of the law, not so much with the enforcement activities.
Thank you, Ken. Yeah, Dr. Vito, any reaction on that?
I think moving on from what Ken has said, or adding perhaps to it, is the fact that within the UK or the English system, there is a clear, I think we have the same in Ghana, right? Where there's a clear outline for what shareholders can do in terms of activism, in terms of standing up if the directors are breaching their duties or not following the principles or the liability regime. In a way, that allows the shareholders to police it. And what we've seen in the UK system is that the shareholders are not afraid to do that. And because there's a clear system, however, it's also not easy, because even if a shareholder wants to bring in a derivative claim, which is a claim on behalf of the company, they will bear all that expense. And unless the company chooses to pay them back, it will be their cost to bear. And all the damages or all the costs will go to the company if they won the case, right? And the courts have a strict process of determining whether the shareholder could bring the claim, including if the shareholder is acting in good faith. So if the shareholder, for instance, has a sort of fracas with the other directors and decides to bring a claim in, just that may disqualify them based on the principle of good faith. So in as much as the rules or the law on paper allows for the shareholders to engage in some form of activism, and here as well, there's the provision that allows for smaller company shareholders a bit more room to bring action because they are seen as quasi partnership, right? So they can bring a claim based on what their expectation, which is called the legitimate expectation rule. So what their legitimate expectation of their role within the company would be. So those sorts of rules allow the shareholders to sort of be the stopgap in between when the company is functioning fine and the law or the directors perhaps are misapplying or mishandling the affairs of the company. That stopgap comes in with the shareholders, and I think that perhaps is the best approach. However, it's not easy. It's not easy to bring a derivative claim. It's not easy to bring unfair and equitable winding up. And a lot of the time, what the shareholder will get is to be bought out. So if you brought a claim, a just and equitable claim for the company, the court may say, okay, you guys have you cannot work together, so these shareholders buy this person out. What do you get out of it? Perhaps that's not what you want. So again, it is great on paper. Enforceability is good if you went to court, but perhaps if you look at it from the human effect or the human side of it, the shareholders may not be getting necessarily what they want out of it. Because what do you get out of being told to be bought out of a company, or for the whole company itself to be wound down and every shareholder takes their money and go away? Perhaps that's not what the shareholders want. So that, for me, I think that perhaps is the problem with the regime, and how to go about it. Perhaps Michael, with your practice, may be able to tell us more.
Yes, I was just about to come to you, Dr. Yamo, and we'll be taking your questions soon. I want your questions pretty shortly, a wonderful audience, but let's hear from Dr. Yamo on this before we move on. And I think one of the things we all seem to agree on is the unique nature of the US jurisdiction when it comes to the fact that litigation is something that your shareholders are not afraid of. So the litigious nature of your jurisdiction. So how does that, sort of apply in all of this in terms of the liability regimes?
No, thank you. I almost want to agree with Priscilla and also Kenneth in the sense that even though we're, again, as I said, we're a very litigious society, these cases are hard to win. And again, as we're talking, sometimes I just kind of check to see if I remember anything off the top of my mind, right? The one case that I think is more recent happened in Delaware, obviously, because Delaware has the director exculpation kind of clause as very recent as 2000, I think 22, if I remember. And a criminal liability is hard, right? Damages are also equally hard, just to kind of get to. So just even here where we have a lot of laws in the books and we celebrate how effective the legal regime, whether in Delaware or Nevada or sometimes Wyoming or even here in the US or South Dakota, Texas, where I am right now, or in South Dakota, these are very hard to do that. Now, the thing that I wanted to Priscilla was getting there a little bit early on. And one was the difference between large shareholders, whether it's private or public, and minority shareholders, right? Now, one of the things that the legal regime here in the US and in the UK, and Priscilla, correct me if I'm wrong, also in the EU, is something that we often talk about as the threshold within which shareholders can bring certain action outside of the court, but within the security system, right, against the company. So in the US, that number, which kind of we call it proxy access in the public equities and whatnot, or filing shareholder or reports and stuff, is usually higher. But in the UK, Canada, and some other places, 5%. You have to have an accumulative 5% or 10% over a certain period of time. So instead of it being one single shareholder, right, who owns maybe 1,000 shares, maybe probably worth like $10,000, who will not be effective and cannot afford to bring a whole suit against a package of lawyers who are well paid by the hour, 1,000, probably 2,000 an hour. You can band together as a group of shareholders, which is not in a way equivalent of activism, but more like active ownership, so that you can actually push against efforts of the company, even call for emergency meeting to resolve certain things. Those mechanisms exist outside of the legal codes. And I know that in the UK, I was just checking and just remind myself, I believe, and maybe Priscilla, you can correct me here, the legal code sits on top of also the corporate governance. Well, no, it works together with the corporate governance sort of code. So in Ghana, you almost have to say that, well, the Independent Director Association have done, some good work in improving the code. They have to lobby to be recognized as in tandem with the legal regime, so that the soft side provides evidentiary mechanism, right, as to whether directors are following in any profession. Are the directors following the bare minimum required of the profession? So if you're a doctor, the Ghana Medical Association provides a certain base threshold of conduct. A nurse, an accountant, the same way for directors. It's a minimum threshold that what our community of experts and thoughts agree that should be the basic and bare minimum. So if it goes to court, the court can easily ask a question: are you even following the basic tenets of your professional jurisdiction. If you're not, that already puts you into a big legal sort of regime because the legal regime will say you are not following even the basic simple tenets of your profession. And therefore, we can hold you at a certain minimum, right, to have the case continue or something like that. So in the US, even though our laws are clear at state level, I'll be honest with you, it is hard to find a claim on the damages that has actually been successful. The fee that comes to mind when I was doing my law program, I remember there was a case where somebody was actually sued with damages. But the problem with that was the person was also had a huge stake in the company and was a private company. So your decisions were a little bit misaligned with a broader group. In this case, his own self-interest.
Yes, thank you so much, Dr. Yamwa. We are so sorry about the disruption. We are doing everything possible to work on it, but please let me apologize. In the meantime, in the event it is not a spam, and I'm hoping it isn't, can our dear audience, can you please mute your microphones? Can we all keep our microphones muted, so that when it's time for you to ask a question, then you can put your hand up and then would unmute you. But in the meantime, if we can please all keep our microphones muted. So I'm just about to come to our audience for questions. I can see that we have some 2 questions in the chat box already, which our team of panel members is going to respond to. But just before that, I think I have one final question before we move on to the questions for our audience. And maybe let me start from Ken on this. Now, taking a look back at all the things, all the knowledge and insights and experience that our panel members have shared, do you think that learning from what happens in these other jurisdictions, there are some local solutions that Ghana can implement further to address these incidents of corporate misconduct? And I say this against the background of the unique and the local realities that we find ourselves in. I always say that, look, in this country, I don't know the extent to which people, tend to appreciate and actually apply the principle of separate legal personality. The fact that even if you incorporate a company and you're 100% shareholder, that does not mean, that you own, strictly speaking, the company, so you can do whatever that you wish with it. So I think these are some of our local realities. So do you think that there are other things that we can pick from other jurisdictions to make director conduct much more, for want of a better word, proper in Ghana? Thank you.
Yes, and in fairness to Ghanaians, I should say that the attitude that people's companies are their personal property is not a uniquely Ghanaian problem.
Okay, if you say
Many
so.
people all over the world would think of their company's assets and use those companies' assets as if it belonged to them personally. And often, in ordinary language, you hear people say, I'm the owner of the company. We know that in company legal theory is an entirely different case. Are there things we can learn and adapt to our peculiar Ghanaian circumstances? In the last 6 or 7 years, or maybe 8 years, especially after 2017, we have done that quite well. You know that after the banking crisis and the problems around the suitability of directors, people had no training or capacity, and then they were appointed to, the board of very crucial companies, particularly state-owned enterprises or, these financial institutions which had some part of government ownership. What we have done well is education. I assume that one of the efforts of CSTS, for example, in that regard, the Institute of Directors have also done some of these SIRIP, etc. Are all the education is increasing. On the regulatory side, there's also a recognition that one director training before assumption of office is crucial, and continued training is crucial. So first, I say that we have adapted things to our local circumstances, because in other jurisdictions, people tend to have long experience before they are appointed into corporate directorships, not so much here. So the response has been that you train people on the job actively. The regulators are also, for example, in the banking industry, the new fit and proper persons directive put out by the Bank of Ghana, showing that not just anybody can be appointed onto the board of a regulated financial institution. And even after they have been appointed, there's a requirement to, have a continuous training towards uh, fulfilling their role. I think also professions and companies themselves are recognizing the value of good corporate governance. So, the soft law dimensions, the professional associations are taking that more seriously and encouraging members to attend corporate governance uh, training, best experience sharing. So, well, the short answer is that we have adapted these learnings from other jurisdictions already, and it only requires frequent improvement. Not so much on the private end of the ordinary small business. That's not the case, but that's where there's a bit of a shortfall. In the more regulated businesses and bigger companies, you have the regulators and the professional associations coming together to ensure that this works. But maybe a much more targeted education for uh, um, medium, small scale enterprises might get value for managing companies properly. So we are in a good place. We just need to do a bit more. And I don't know if it's government's responsibility to lead the charge on education. I can't tell. I have no views on that.
I guess it's all of us. We can't leave this to government alone. But I think I'd want to come to our audience for now. If you have a question, first of all, there are quite a number of options. You can type them in the chat box and would address it. Otherwise, you can please put your hand up and then I would call on you to ask that question. But we have, talking about SOEs, Kenny spoke about SOEs. We have a question from one of my senior brothers here. So his question is, my question is, how do you encourage shareholder activism when you are dealing with a state-owned company where the government is 100% shareholder? So how do we encourage shareholder activism when you are dealing with an SOE where the government is most of the time 100% shareholder? I don't know which of our panelists would want to take a bite at this. Michael, you want to? Okay.
Yeah, I mean, I have some experiences in South America and also Asia. I think the question is actually asked the wrong. Well, it's correct, but it's in a way you could flip it and say, what do you mean by a shareholder? Yes, the government owns a majority stake, maybe 100%. But the way we look at public markets is that the government often will also issue bonds or other forms of financial instrument to raise capital, or the finance ministry will do something to raise capital for that specific state enterprise. So you see that same kind of structure happen like in some Asian markets and also in a lot of the South American market. In this case, what happens is it is the secondary market, right, which is a secondary form of ownership that starts saying, okay, if all your this actually is a classic example that I think happened in Brazil in some of the oil and gas state agencies, where a number of foreign purchases of state enterprise or local purchase of state enterprise bonds or whatever that went directly into that demanded that before they will actually pay for any bond or any kind of investment on that, they demanded more independence on the board, at least one. There were successes in some of those cases. So it was a secondary ownership, right, which is more of like the source of the capital that often activated a change. And I don't know, again, sometimes I talk to Dennis and a number of people, I was like, the law is great, the law is great, the law is great, but you have to find a system of market practice to kind of make something like shareholder activism work. Sometimes it could just be pension, I'm just putting in an example, pensioners, like as it happened in Asia, who are just saying, listen, our monies, some of them are going to these state enterprises because we track a lot of our, and they band together through some of the unions and stuff and demand those kinds of, this happened in the early days of Europe, right? Even in the UK in the early days of a lot of the state-owned enterprises before Carter and the rest kind of disbanded some of the state ownership principles into private ownership principles. I do think we can do the same thing in Ghana. I'm not sure what the legal spectrum is. Can comment on it, but this is also an effective way. I tell Dennis all the time. The way we've seen Brazil, Singapore, Hong Kong, and other countries, and even now in South Africa, changes when you start seeing greater board transparency, greater governance transparency, and greater shareholder value. you start attracting more capital. Because let me tell you, banks and investors are in the business of taking risk. They know that the money could be gone any point in time, but the only sort of reaction to any regime is who is responsible for overseeing the money that I have invested in, right? And that often comes from good corporate governance. It's actually one of the biggest lever of how we, in many part of the West and even in emerging markets, how investments are made. So I hope that answers the question. So government owns 100%, but the government doesn't just throw money. They seek the money from somewhere, and the secondary ownership can become a good buttress for how you deal with SOEs.
Right. Thank you so much, Dr. Yamo. Closely related to that, there's a comment by Joyce Boateng that I'd want to read out here. It's closely related to what you just addressed, but she says, how is misconduct addressed in companies where the government has a majority stake? With every change in government comes a change in the board, as political authorities appoint almost the entire board, including INETs, often reducing independence to a mere box-ticking exercise. Although the legal and regulatory framework exists, their practical enforcement is frequently undermined by political influence. In many cases, political actors sit simultaneously as board members and regulators, creating conflict of interest and weakening accountability. This situation is deeply unfortunate and poses a serious challenge to effective corporate governance. Thank you so much, Joyce Boateng, for that. So one of the platforms that CSTS also has is the corporate governance series. We had one in November in collaboration with the Gimpa Law School, IOD Ghana, and then the State Interest and Governance Authority. And this was actually on strengthening corporate governance of SOEs, opportunities and challenges. We had very senior, practitioners dissect all the issues relating to SOE. So what we can do, perhaps, Marie, if you can kindly share the link to that earlier discussion that we had in November for the benefit of our audience. I'm sure they'll, pick up one or two things from that discussion. And then Ken, there are quite a number of questions here for you. Let me put them together. So one says that you talk about people who have no training and experience being appointed to boards. What specific training, particularly, which specific institution and experience must a person have before being appointed to a board? Then the second one for you is asking that, can you throw more light on the issue of directors' liability in relation to shadow directors and de facto directors? So those are all yours.
Okay, let's compare first before I go to the question. Let's compare, for example, when the Nigerian-owned Ghanaian banks and their selection of directors. You can see the director profiles which they put up. And very often the banking industry is our measure for the sort of seriousness with which we deal with corporate governance issues, because people's lives are always heavily connected to, regulated financial institutions. If someone, I do not say, for example, that someone should have a law degree or should have a master's in corporate governance or corporate law to be able to be eligible to be a director. But at the very minimum, in appointing someone to a board, they must know what their duties are, and they must know, the requirements, that they're not just there to receive the allowances, which is often when people congratulate their friends and colleagues who are appointed on boards, the social media frenzy is often about what they're going to earn, but not what their duties are in relation to the company. And in Ghana at this moment, there are options. CSTS, IOD, some of the other professional organizations do in-house training with corporate governance. Those are options available. And once people have come on board, their past knowledge may be useful for directors generally, but they must also understand the very specific industry. So you can be a very experienced director in petroleum, but you might be found wanting a board position in banking, unless the transferable knowledge from petroleum or the systems that they can, of course, there's always a chance to transfer knowledge and experience to these. So one would hope that they get some corporate governance training at the very minimum, and not because perhaps in the previous year before the election they were shouting on radio. On the second question about de facto, it was Priscilla who actually brought home that point, that in the UK you may not be a duly appointed director, but if you act as though you were one, or if the other board members were accustomed to obeying your instructions, you might be subject to liability as a director. So I think going forward, and that's also the situation in Ghanaian law. So one of the ways to remedy interference in SOEs, for example, is to, when there has been misconduct on the board, to lump in those who are on the outside of the board giving instructions to the board, so that when there are problems, these people should become subject to the misconduct and liability regimes. And if that were to be enforced, there would be at least one would hope that there will be far less likely incidents of, interfering with particularly public owned public ownership companies. Yeah.
No, that's fine. Thank you so much. So, our dear audience, we have shared in the chat box the link to our earlier corporate governance series discussion on SOEs. So you can watch that video on YouTube, and there are quite a number of things that you can learn from there. Some of our friends had also asked, what are some of these institutions that offer the corporate governance trainings, and how can they be members of it? These are all institutions that people like Ken and myself are members of, so I have taken the liberty to share the link to their websites. So I've shared the link to the website of the Chartered Institute of Restructuring and Insolvency Practitioners, CIRIP, and also that to IOD Ghana. You can please take a look at it, look at the what it takes to be a member, and then you can please speak to them further on that. Thank you. Okay, so I think that I can address this question to Priscilla, Dr. Vitor. There's a question that, does increased shareholder activism genuinely, and I like the, the use of the word genuinely, improve corporate governance, or does it risk pushing directors toward short-term self-interested decision-making? So Gabriel Nfibuesiako is asking whether increased shareholder activism genuinely improves corporate governance, or does it rather risk pushing directors towards short-term self-interested decision-making? Priscilla, you're muted. Yeah.
Yeah, sorry, thank you. I would say it's both, because in as much as increased shareholder activism genuinely would, I think, encourage directors to be more proactive and to be more cautious of decisions that they are making. Because if you know that there's a shareholder who is watching behind your back and would not be afraid to go to court to challenge the decisions that you have made, then it's likely that you would make some decisions with more care and skill. However, on the other side of the spectrum is causing the short-term sort of directors trying to protect themselves. So I think it's a spectrum, and it can go either way depending on how that shareholder activism is done. So if it's a shareholder that is going to court every 2 minutes or threatening to go to court at every instance, then of course directors will start taking short-term decisions, or taking short-term strides to protect themselves. Whereas if it's something that it is seen as this is done in the interest of the company and perhaps it's a way of oversight, then that may be different. I had my hand raised because I wanted to ask Ken about corporate company secretaries. I know that in Ghana, a lot of the time they end up being lawyers. Has that changed, or is there a company secretary role within Ghanaian institutions?
Well, now the requirement is that one must have received training to become a company secretary. You need not necessarily be lawyers, but obviously lawyers also tend to take the majority of the position. But now there are specifications that you must have training to be a company secretary. So that's one of the changes which happened with the Companies Act 2019. But now there are chartered secretaries. So they are not lawyers, but who train as chartered administrator and secretaries, and I know a few of them working as company secretaries.
Okay.
Yeah, so I think that our audience can look at and for Ghanaian law section 211 of our Companies Act on the qualifications to be appointed as a company secretary. And like Ken said, it's one of the new modifications under our new Companies Act, which is also very, very important. Company secretaryship has not featured much in our discussion, but I think it's good that Dr. Vitor mentioned it. Yes, Dr. Yamwa, your hand is up. You have some intervention.
Oh, sorry. I got distracted for a second. So I just wanted to kind of raise a couple of things. Maybe this is just a suggestion. I'm very careful because I know I'm in the midst of lawyers, so I'm going to say this sort of carefully. I think there's a risk, Kenneth, you're making this point that you don't want to. So here's one thing about corporate governance universally, right? There's been a longer trend of evidence that has shown a more diverse set of directors from different backgrounds are better, and I'm not talking about diversity based on ethnicity or race, but just skill set, right? I don't know in Ghana, but both in the UK, in EU, and also here, but other places as well, the ultimate goal from oversight, which is why in many cases directors are responsible for strategy, M&A, and growth, right? That's what they're supposed to do. So coming into a director role in the US and the UK, onboarding is a very big part. You don't have to go get a certification outside anywhere. We look at it like the company that is bringing you on board owes you a legitimate responsibility to onboard you as in regards to your duty. Part of that onboarding process is for you to maybe understand what the rules are. In many cases, sometimes we say that do not, as a board director, you always have outside counsel, number one, internal counsel as well, right? So that's the best way that we often try to invite more different. So in Italy, in France, and I think in Spain, you even have employee option to be on the board as well. Even in state sort of entity, there's a little pass where there'll be an employee or a union representative on the board, as an example, right? Who comes in. And that person may just be a mechanic who has just been working at a company for 40, 50 years. It happened in Italy, right? But when they come on board, the company, as part of a core responsibility, is supposed to help them understand what your role is, right? So I just want to make sure that, we don't want to kind of parameterize by saying you have to have some legal education, because you might get into some of the early years in the United States, right, where if most of you may not know this, but early in the history of the United States, to even incorporate, you had to go to Congress, and that limited the growth of a lot of companies. It wasn't until they said, open it up, let us put it into a much more regulatory body, open market body, that they started seeing capital flow from the UK coming into sort of the country. There's also two things, Priscilla, you made mention of that I wanted to capture. When we talk about shareholders, somebody asked about short-term thinking. Yes, you're activists, right? Who basically are there for 3 to 5 years looking for profits and just to turn around. So for instance, I work for an asset manager. We only look at long-term because we manage pension years. So we have to look at 30-year horizon, right? So we are what we call classic asset managers, where long-term thinking has to be the de facto sort of thing. So we hold boards accountable. So in Ghana, we obviously have to look at a different spectrum of shareholders. You have those who are there to be pure. Again, there's a difference between activism and active ownership. So you can be a long-term shareholder with active ownership, which is what I do. But you can also be an activist investor, which is you're just coming in quick 2 years, making money, sell like a PE, and then you go away. So the different class of investors and shareholders and stakeholders need to be quite clear for us to be able to say, okay, here is how we want to expect things from different part of different entities. So I just want to make sure that at least that is clarified.
Very useful points. Thank you so much. I think there's a very important question from my friend Divine Akotia here. Divine is asking, how do regulators determine whether misconduct is a system failure or a director level failure? So how do regulators know or determine whether misconduct is a system failure or a director level failure? And then the next one that I think we'd want to address from Gabriel in Fibuesiako is asking, if directors must act in the best interest of the company, how should they respond when a majority shareholder's demands conflict with the long-term sustainability of the business? So in cases where a majority shareholder's demands conflict with the long-term sustainability of the business, how should directors respond to that? I don't know whether Ken or Dr. Victor would want to address any of that.
Let me take a quick one at this. Within the constituencies of any company, there's always a tension between majority shareholders, minority shareholders, with the board, etc., etc. The board's role is to navigate all these different interests in the best interest of the company. Very often, well, the majority shareholder has the voting power to replace members of the board. And that's always the risk that, board members might be more willing to do things that satisfy the majority shareholder in the hope that at the next AGM or EGM, they would be able to retain their seats. But in the common law world, at least with the US, UK, and Ghana that we're discussing, the board's duty is not to the shareholders. Well, yes, they must act in a way that has the long-term benefits to shareholders in mind. But the board's duty is to the company. And very often, once the board has acted well in their best interest of the company, it trickles down to the shareholders. So the simple answer is that the board must look out for what is in the best interest of the company and not necessarily what is only in the best interest of the majority shareholders. Because sometimes what is in the interest of the majority shareholder may not be in the long-term interest of the company and would thus affect the minority shareholders. I'll leave the other question.
Okay. Dr. Victor, would you have a viewpoint on the other question, please?
Sorry, can you repeat the other question?
Okay. So Ken, I believe you answered the question on whether how 1 second.
I answered the question about what should the board do in
Good.
relation to the majority
Good.
shareholder asking them,
Great.
yeah.
Great. So the other question is, how do regulators determine whether, the misconduct in question is a system failure or it's a director level failure?
Wow, that's an interesting one. I think a system failure can still be a director level one, and it will all be down to investigation, wouldn't it? Because if the system, is it a system in terms of the company's system or in terms of the regulatory system? If it's a regulatory system, then first, if the director, there's a failure in terms of what the director has done, then the regulators would have to look at how their regulation has perhaps left this gap or has caused this director's ability to take these actions. So, for instance, when we've had cases, I think, Michael, you alluded to some of them where the courts were asking, did you take another audit? Did you actually look at the reports? And
2026, and so that's so fair WhatsApp call.
Sorry about that, please.
and then Ken, you were talking about how the new act in Ghana required for directors to exercise independent judgment based on the learnings from the banking crisis in 2019. So that would be the regulators realizing a failure based on their regulatory system being unclear and causing that. And so, for instance, in the UK, we have cases where the courts have had to explain what acting in reasonable care and skill has been. And that is because perhaps the director has done something or even conflicts of interest where I think there was a case at the theater, I don't remember the name of the case, where the directors took the opportunity because the company did not have the money to buy that theater. But when the courts looked at it, they explained the conflict of interest rule as even if the company cannot afford it, the directors still cannot take that action without the say-so of the company. So that is a system failure where regulators will have to look at and see if it's an issue of their regulation. In terms of if it's a system failure based on the company or if it's a director failure, I think a director failure will be a system failure if it's internal. Perhaps the others can help me.
But I think that largely answers it. But I see something very interesting, which points it screams Dr. Yamwa throughout. It asks that at what point does poor business judgment become corporate misconduct? This from Ramat Waja.
Yeah, that's a very good question, and maybe I'll borrow what Priscilla was working on. If you're in a boardroom, your goal is to try to have consensus. To be honest with you, the goal is to have consensus. If you have any director who says, abstain from this or that, could actually expose the entire what I've learned to greater sort of scrutiny. And so sometimes when decisions are being made in the boardroom and there are quite a number of dissent, you're not looking for groupthink. What you're looking for is robust dialogue, but you're also trying to pave the way of what is the best sort of risk mitigation efforts, which kind of derives the consensus sort of building rather than the opposite of, say, groupthink. Because a lot of misconduct are claims about whether proper care, proper oversight was sort of administered and whether independence was really clear. So if they were in the US, there was a case I mentioned earlier before where there was a particular director who had a particular unique significant stake in the company, and you could see that in the meetings that were kind of submitted to the courts, there were clear objections from some directors, but eventually, you could make a presumptive guess that, well, the only reason why the vote went through, the decision was made was purely because the person had a sort of a stake or there was a relationship. Now, there's something I don't know if this in Ghana, maybe Kenneth and Priscilla or Gertrude, you yourself can speak to, but in the US and in the UK, a lot of board proceedings are summarized in many ways for disclosure purposes to investors. So board members can actually paraphrase or in many cases disclose out and say, we responded to A, B, C, D things from maybe a third party. We looked into a particular board member who was supposedly connected to the CEO's daughter or something. Those things all come part of the disclosure. And also we do encourage, I'll be honest, we do encourage third-party board audits. In fact, it's become something that I've been asking for a lot here in the US and also in other jurisdictions where I say, I get it, the internal audits that HR or other people do with you. No, once every 3 years, we want to ask a simple question. Is there enough independence, enough subject matter expertise, diverse opinions, and have there been proper assessment whether every board member is effective or not? Those are ways that we measure and decrease misconduct, but also avoid the risk of misconduct.
Okay, thank you so much, Dr. Yamwa. We are just about wrapping up, but I would want to take some final words from Dr. Priscilla Victor, because she has to take leave of us in the next 1 minute. So I'll just take some final words from her, and then we can wrap up in the next 3 minutes. Yes, Doc, please go ahead.
Thank you for organizing this. Found it quite interesting. Thank you for having me. I would say that in terms of all that we've discussed, we should recognize that being a director is not just a paper function, or it's not just accepting to have your name on the papers or the documents of a company without necessarily doing anything. I think as the law has evolved and as oversight and as society begins to think more, and as other stakeholders in terms of the public, in terms of shareholders, start to look at what companies are doing. And as for instance, in Ghana, I think when companies begin to grow, there'll be a lot more that is expected of directors. And so as directors, to take that role more seriously, if not, and to make sure that you're getting the requisite knowledge, or if you do not, having the right people within the institution that can feed that knowledge to you and ensure that you are in compliance with the rules, and to not take those positions lightly.
Thank you so much, Dr. Victor. She joined us from Loughborough University, England, where she's a lecturer in law. So we'll just take final remarks from our other panelists. Thank you, Priscilla. Thank you so much for making the time. We are so grateful. So we'll just take some final remarks from our panelists. But before that, our dear audience, you would have realized that I have posted a link to the website of CSTS Ghana. I'd want for all of us to click that link to open it, because one of the things that we are seeking to do is to build our own network of corporate governance researchers and advocates through events such as what we are having today, the webinar series, and then the corporate governance series. The next one, which is the corporate governance series, will come on the 12th of February. At the Gimpa Law School, and it will be on the subject of corporate governance of banking institutions. That's an interesting one that I know we'll all look forward to. So please click on the link that I have just shared in the chat box, and also join our network to receive prompts and materials that we'll be sharing periodically. You can actually also submit articles for publication in our blog post. So if you have any article at all that you related to corporate governance, corporate law, you can submit that to us. If you leave your emails, we would, like I said, be sending you notifications, okay? So please remember to click on the link to know more about CSTS and for the opportunity to join the corporate governance network, which we are creating. So okay, so my dear panelists, please permit me. Mr. Bonsu, is your hand up? Are you online? Let me just get the opportunity to ask. Yes, just this one question and then we'll move on. Yes.
Thank you for the opportunity. It's an interesting question I do have. If you have a director who is a shareholder and actually the investor of your company and decide to store the company by not pumping in a lot of money because of a conflict that ensue between or among the directors, how do you handle such a situation?
Okay, thank you, Oxford. Ken, Michael, which of you would want to provide some insights on this?
I mean, from a practical point of view, you just have to excuse yourself as a director, right? Now, what I've seen companies do, I mean, if there's a reasonable person, a chair or something, they could directly excuse that specific director for obvious reasons. But in many cases, what I have seen happen, and I don't know if it will ever happen in Ghana or other places, other places, is that the board will basically declare that they will need an external sort of party to sort of help move it in the right direction in terms of the decision. And that is often the case that happens. The board will quickly hire a third-party consulting firm or something like that of the equivalent. It happens usually with a lot of the accounting and audit. It also happens with a lot of risk as well. So yeah, these things actually happen very often, especially at the private company level. And that often becomes the arbiter of truth with third-party entities involved.
Okay, right. Thank you so much, Michael. Ken, perhaps this is a good time to take your final words and then we can wrap up.
At least thank you for the opportunity to join this very interactive seminar. My closing words will be that bad corporate governance can have, serious consequences for everybody. So people who are giving the role of directors in any type of company must do so with a lot of trepidation about the importance of the responsibility, and particularly on state-owned enterprises and regulated institutions. Your decisions can affect people for many, many, many years. So that's what I'd say.
Thank you, Ken. Dr. Yamwa, any final words for our audience?
I do agree with Kenneth. I think the ultimate goal of serving on the board is obviously not just for monetary reasons or just because of what you know. There is a unique, how do I put it? It is a unique opportunity for you to help a company move in the right direction, particularly when it comes to growth. So even if we are dealing with a state-owned enterprise, I think you have to look at that fiduciary responsibility that you owe to the company, to the investors. And in this case, if it's state-owned enterprise, it's to the shareholders are Ghanaians, right? Yes, the government is an entity. So think of that and the wider societal impact of that role. And I think when we start moving in that direction, we will begin to realize that there is opportunity in actually embracing a much wider network of people who can participate in the board. One thing I also encourage all of you, as you also do, is like in many parts of the world, we are encouraging for more new and fresh board members. It may sound funny to you, but tenure on board is a big problem. It creates entrenched positions. It creates unlearned behavior. So yes, people should go ahead and take lessons about corporate governance, but I think we all as a society need to realize that there are younger minds and fresh. I always tell board, look for first-time board members, right? It's very important. They bring in new ideas, new challenges, and we need the boardroom is as lawyers, the boardroom is a great place for debates, and that's what you want. And nobody has to be an expert in aerospace to be on an aerospace board, but because they could bring additional experience around just regular person who hates the noise of flights going over his roof and wants us to fix it, which has actually been a real case that has happened in some part of the world. So
Right. Thank you so much, Dr. Yamwa. So this has been the CGS webinar series. It is an initiative of CSTS. CSTS is a Corporate Secretarial and Training Services Limited. We have just shared the link to the CSTS website, which allows you to be or gives you the opportunity to join the Corporate Governance Network, which is a growing network of corporate governance practitioners, academics, researchers, and what have you. I want to take the opportunity to thank our panelists who joined us this afternoon, Dr. Priscilla Victor, who is a lecturer in law at the Loughborough University in England. Of course, Mr. Kenneth Gate, who is a lecturer at the University of Ghana School of Law. And then, of course, Dr. Michael B. Yamwa, who is a director with Investment Stewardship and Engagement Federated Hermes Limited, which is both in London and Pittsburgh in the United States of America. My apologies to those questions that we have not been able to attend to for want of time. But what I'll say is that please send those questions which have not yet been answered to the CSTS email, and we can reply or even share them with the panelists and share their responses with you. So thank you so much for our audience who have joined us from all walks of life, both in Ghana and outside of Ghana. This is just, one of many other series of webinars that would be coming your way. So thank you for taking the time to join us in this learning experience. We'll be in touch in the next few days, weeks, and months as we continue this corporate governance advocacy that we have started. Thank you all very much, and do have a beautiful evening and a wonderful week. Bye-bye from us.
Thank you.
Thank you.
Thank you again. Bye.
Thank you.
Gertrude,
Yes.
sorry, is it possible to get the recording?
Yes. So we'll share it with all those who registered. I want to believe that you registered before
Sure.
getting the link. So we'll share the recording with all of you. Thank you.
Thanks.
Right.
Thank you. Thank you.
Thank you.
Thank you.
Bye.
Thank you very much.
Thank you. Bye.